Okay, looks like everyone's here. Shannon, put us on the record, please.
Okay.
Good morning. This is the matter of the Ballou miners. We have Mr. Way for the petitioner. We have Nia Tyler and Brittany Haynes for the agency. And counsel, I'm not sure of your respective roles. If you could each state your appearances.
Ivan Brown for Stephanie Hadley, mom.
Ken Hotchkiss for Alan Ballou, dad.
Rebecca McCluskey, guardian ad litem.
Okay, and Ms. Hadley and Mr. Ballou are both participating by telephone. Can you both confirm that you can hear me now?
Yes.
Yeah.
Okay, my understanding is that a no contest plea will be entered by each of you today. Counsel, what is the basis for a no contest plea?
Judge, there's a potential for criminal liability, and I have one preliminary matter before we start, just housekeeping.
Okay. Go ahead with that, Mr. Brown.
On the petition, it indicates that Chevelle Ballou and Callie Ballou were born, one was born 4/7/2019 and one 4/17/19. Unless they're twins or something occurred that is quite unnatural, I would assume that those are incorrect.
I think that's probably a safe bet. So, parents, what are the correct birth dates for each of your children?
Malia was born on August 31st of 2017. Chevelle was born April 7th of 2019. And Callie was born April 17th of 2020.
2020. I'm going to correct the petition right now to reflect that. Okay, so I'm going to ask each of you, Mr. Ballou and Ms. Hadley, to raise your right hands. Do you each solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Hadley?
Yes, I do.
And Mr. Ballou?
Yes, I do.
Okay. Can you confirm to me that you are the parents of Malia, born August 31, 2017, Chevelle, born April 7th of 2019, and Callie, born April 17 of 2020, all with the last name of Ballou.
Correct.
Yes, that's correct.
Okay. I'm going to try to turn the volume up on my end a little bit. And can you also confirm that each child was located in the county of Jackson when the petition was filed?
Yes, sir.
Yes, sir.
Have you each read the petition, and do you understand the allegations that are stated in the petition?
Yes, sir.
Yes, sir.
If the court accepts your plea today, there will not be a trial, and therefore you would be giving up all of the rights that you would have at a trial. Those rights include the right to a trial by a judge or a jury, the right to have the petitioner prove the statements in the petition by a preponderance of evidence, the right to question the witnesses who testify against you, the right to give testimony on your own behalf, and the right to have witnesses subpoenaed who you believe would testify in your favor. Do you each understand that you will be giving up all of these rights if I accept your plea today?
Yes, sir.
Yes, sir.
If the court accepts your plea, the following consequences might happen. There will be continued investigation by the caseworker to see what the problems are in your home and family and how and whether they might be solved. the case could be dismissed if there's no need for further court involvement. If there are problems in your home and family that can be solved, the court could make your children temporary wards of the court, place them with either parent, with relatives, or in foster care, and order programs and services designed to solve the problems. If the court determines you are unable to provide your children with a suitable home in a reasonable period of time, the court could terminate your parental rights, and your plea can be used as evidence in a proceeding to terminate your parental rights. Do you each understand all of the consequences that I've just explained to you?
Yes, sir.
Yes, sir.
If your parental rights are later terminated, your obligation to support each child will continue until a court modifies or terminates the obligation, until an order of adoption is entered, or until the child is emancipated by operation of law. Appellate review is available to challenge an order of disposition following adjudication, and such a challenge can include any issues leading to the disposition, including errors in the adjudication process. If you wish to seek appellate review and cannot afford an attorney, one will be appointed to represent you on appeal and to assist you in obtaining the necessary court transcripts. You may be barred from challenging the court's assumption of jurisdiction on appeal if you do not file a timely appeal of the initial dispositional order. Do either of you have any questions about anything I've told you so far?
No, sir.
No, sir.
Has anyone threatened you or promised you anything to get you to enter a plea today?
No, sir.
Are you each entering this plea of your own free will?
Yes, sir.
Do you understand that I will treat your plea the same as I would an admission of responsibility?
Yes, sir.
All right, I have been provided with an excerpt from the CPS report, which has been marked as Petitioner's Exhibit 1 to provide a factual basis for my acceptance of your pleas. I'm going to take a moment to review that to myself. I have reviewed Exhibit 1. And I find that it does provide a factual basis for my acceptance of each plea. Counsel, do you believe the court has complied with MCR 3.971?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
I do accept both pleas. I find that they were knowingly, understandingly, and voluntarily made. And I find that petitioner's Exhibit 1 supports that one or more of the statutory grounds alleged in the petition are true. Are we prepared to move forward with disposition today?
Yes, sir.
Ms. Haynes, are you
Ms.
prepared to give recommendations?
Yes, I'm sorry.
Go ahead.
It's recommended that both Stephanie and Alan complete drug screens, that they complete parenting education, substance abuse assessments, counseling, a psychological evaluation, and domestic violence education.
Included within those requirements would be to follow all recommendations resulting from either assessment, either the drug and alcohol assessment and the psychological.
Correct.
Counsel, any objection to these recommendations?
Judge, just briefly, I don't know whether you call them objections or not, but that's quite a healthy list for these parents. I would ask, my client's well on her way. She's already attended several counseling sessions. I would ask that the counseling that she's currently doing now address the DV issues. Having two therapists or two separate therapists or two separate classes along with all of these other requests, I think is quite cumbersome. Further, with regard to the drug screens, I would like to know the frequency of them, whether we're asking every day or once a week. I want them to be successful, so I don't want them to be overburdened with so many. This is quite a list for anybody. And while I'm here, the allegations that we started out with were the result of not adequately working with the prevention team. There was no allegation that the children were harmed at the time, although I'm not saying that over time these allegations couldn't result in psychological and physical harm. But we would ask that if Ms. Hadley and Mr. Ballou have a period of, let's say, a month of negative drug screens, that the court allow discretion to go to some form of unsupervised. Thank you.
So certainly, if the counselor that either party is seeing is able to address all of the issues for which counseling is required, I would want that to happen. But if they're not, I want to make sure whoever's doing the counseling has the experience. A drug and alcohol counselor probably isn't equipped to do domestic violence counseling. I just want to make sure that they have that knowledge and experience base. But of course, we don't want to double up on counselors unless it's necessary to reach the particular expertise. I think that makes sense. As far as unsupervised parenting time, I am willing to grant discretion to the agency, provided parents are fully compliant with all services and testing negative, that the agency have discretion to allow some unsupervised parenting time.
Thank you.
Mr. Hotchkiss?
And I think the court's comments addressed my concerns for my client. He has begun services on his own through Lifeways, attending therapy and so forth. So my concerns are essentially that Mr. Brown raised, and the court addressed those. So I wouldn't have anything further. Thank you.
Okay, so Ms. Headley and Mr. Baloo, I want to encourage you. I'm happy to hear that you both already voluntarily begun some services. This is not a criminal proceeding. The goal of this proceeding is to help you. We truly want you both to be successful as parents. We want to be able to return your children to you. The best place for kids is with their parents, provided the parents are able to provide them with a safe home. So we're very hopeful, and we'll do everything that we can to try to help you to be successful.
Okay, thank you.
Okay, we will do our first review hearing on
June 15th at 8:45.
June 15 at 8:45.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you all.
Thank you.
You're welcome. Good luck to both of you.
All right, thank you very much.
Okay, give me a moment to. Okay, looks like next we've got a couple of post terms. Let me see. Let's do Brittany McLean first. So, Ms. Norman. Okay, this is a matter of Brittany McLean. We've got Ms. Osfarita Norman for the agency. And who is LGL on this file?
That's me, Your Honor. Rebecca.
Are we expecting anyone else?
The foster care worker should be present. Her name is Molly. What?
Molly Wagner? Okay, here she
Yeah.
is. Good morning, Ms. Wagner. We're doing the Brittany McLean post-term hearing. So, Ms. McCluskey, how is Brittany doing?
Your Honor, the caseworker information I have, I emailed her. I called both numbers that I have for her. One was not working. The other, I left a message in a mailbox. I tried to call Holy Cross directly to reach Brittany directly, and they could not find her. So I was unable to meet her speak with her despite several attempts. I did review the court report. It looks like Brittany's doing fairly well, and I know she's had a lot of struggles, so I was glad to see that. I have no objection to the recommendations. Thank you.
I'm not sure I recognize everyone that's in the waiting room right now, but it seems that Brittany has participated in the past. I don't see anyone signed in under her name. Is there a name of someone at placement associated with this file?
I'm not 100% sure if she's going to be joining us. When I met with her last week, she said she had a doctor's appointment at the same time. So I'm not 100. I don't know who it would be under.
And I'm just looking at the Holy Cross Services report to see if there's any name mentioned in it that shows up in my.
Her case manager there is Miss Palmore. So it could be under her.
All right, I'm looking at the signature page of the report. I don't see anyone in the waiting room matching any of those names, so I don't think she's here.
Okay.
Do either of you have anything to add?
I don't have anything to add.
I don't have anything to add, Your Honor.
All right, well, I will, if you could follow up and make sure that Ms. McCluskey has correct information in order to connect with Brittany, I would appreciate that. We will set our next post-term hearing for June 8th at 8:45. Thank you.
Thank you.
Okay, next up is Henry and Zachary Kemp. And it looks like Mr. Hotchkiss is LGAL. We've got Chelsea Kirkpatrick and Amanda Getting. And I don't see any other names in there. Mr. Hotchkiss, how are Henry and Zachary doing?
Gunner, both are doing very well in the placement. Ms. Junga reports that they're meeting their milestones. They're thriving, well-adjusted, and very pleased to be moving forward with the adoption process. I reviewed the report. Looks like some progress is being made, and I support that recommendation. Thank you.
Ms. Kirkpatrick or Ms. Getting, do either of you have anything to add?
I do not.
Your Honor, I would just like to add my court report did not reflect a home visit for the quarter. I had a home visit on Friday, March 12th. And then just to update as far as subsidy for both boys will be submitted today. So I anticipate getting that in the next 2 weeks.
So I see an anticipated date in June. Is that realistic?
I think I have May on my report.
Oh, okay. It didn't jump right out at me. That was from the other report. Well, that's great.
And I do feel that's realistic in this case.
All right, good. I will implement all of the recommendations. I will set a post-term, if necessary, for June 15th at 8:45. Thank you all.
Thank you.
Thank you.
What'd you say, Judge? June 5th?
June 15th.
Yeah. Oh, well, that's, hang on, I'm on the wrong. Okay, sorry, my bad. Never mind. That's right. And then all this is just what I got about Almac. There's all kinds of updates on that one.
Okay, and let's see. Next up is the AUMAC minors. And we bring in Caitlin Williams and Mr. AUMAC. And as soon as I've got a connection with everyone, we will move forward. Okay, looks like we're connected to everyone. Mr. Almack, you can hear me?
I saw an X. I don't think he connected.
Your Honor, while we're waiting, I did invite the school counselor to speak on kind of their schooling. Her name is Janessa Cole. She should be in the waiting room.
She is not.
Okay.
And I have a quick motion when we start.
All right, well, as soon as we connect with Mr. Almack, he's having some difficulty. It's not showing my normal signal when somebody's having trouble connecting, so I'm wondering if he doesn't have his settings. Okay, I've got that back. It says it's connecting to audio. Mr. Almack?
Burner.
Mr. Almack, can you hear me now? I'm going to try calling him. And I do have Ms. Cole present.
The number you have reached, area code 517-296-1798.
The subscriber you have dialed is.
All right, I tried each number that was on the petition. Does somebody have a current phone number for Mr. Almack?
Janessa, do you have any other numbers than what was on the referral? I know you spoke to him recently.
That I got yesterday, it looks like he may have left me a message that I didn't get to yet this morning, and I've got 414.
The contacts that the 414-1529.
All right, I'm going to try that now. No, it didn't go through. Let me try again.
Hello.
Mr. Omak.
Yes, I'm sorry I missed last time, Judge. I'd never got in the room. I didn't realize it was going to be 2 hours. And now I don't have audio, but I can see you, sir. I would normally not miss a court date with you.
And we can hear you now, so that's good. All right. So this is a matter of Aiden and Sophie Omak. We have Mr. Omak present by video and by phone. Mr. Brown is the LGAL. Mr. Wade for the agency. Caitlin Williams, and also present is Janessa Cole from the school. So, Mr. Brown, you wanted to be heard first.
Yes, Judge. It's. I'm sure there's no surprise what Ms. Cole will say if the court wants to hear from her, but I undoubtedly she's going to say that the children are not doing well in school. As we spoke last week on the record, this is a recurring situation year after year. I spoke with Mr. Way, and this is done at times when Ms. Bates was the referee. If you look at your order, the order after pretrial, number 22, you have the authority to require that the Department of Human Services open up a file and place the children in the custody of DHHS. I would ask that we adjourn this 2 weeks. I wish the children were there today so they could hear this. They're of an age where they should know what's going on.
Not sure that they are.
Hold on a minute. Hold on a minute, Mr. Omak. Don't interrupt.
I would ask that they be given a couple weeks to go to school and show progress. Otherwise, the court order that the children be placed in the custody of DHHS. This is an ongoing situation, year after year, excuse after excuse. I think this is abuse. So the children need to get to school, and I would ask the court to look at that order. And if the kids are not in school every day, that this court issue an order placing them in the custody of Department of Human Services. Thank you.
All right. Well, Mr. Brown, I am very sympathetic with your request, but at this point, neither Mr. Omak nor Ms. And I'm sorry, I lost the mother's name.
Flynn.
Ms. Flynn, have attorneys appointed to represent them. So, Mr. Omak, it is your right to be represented by counsel in this matter, either someone of your choosing or someone appointed for you by the court. Do you wish to have the court appoint someone to represent you?
Can I talk to Sean Carroll first? Like, they are both registered to go to school on Thursday. They both have promises on their big sister's grave that they're going to go without trouble. I mean, I don't have excuses. This one was Corona and their big sister died, but I can't beat their ass with a belt to get them on the bus. So yes, I'm too lenient, but I'm not. They promised me they'd go to school. If I get them up, get them on the bus. I said, boom, let's do this.
If you want to retain private counsel, you certainly can, but I just wanted to make sure you knew that you could have an attorney. And
Yes, sir.
I would not order your children removed without making sure that you had counsel to represent you. Mr. Brown's request is not that I do this immediately, but rather that we see if you follow through on the commitment that you've made and that your children have made to you. So before I say anything else about that, let me hear from, is it Janessa Cole?
Yes.
Okay, Ms. Cole, what is your role?
I'm the community school engagement specialist here at Da Vinci Schools and also the attendance liaison and homeless liaison.
Yes,
and I do
K-12.
K-12.
And you'd like to address the court on the matter of the school attendance of Aiden and Sophie Almack?
Correct.
Go ahead.
They have, so going through attendance, I know that they were turned into truancy last year as well, since they've been with us at Da Vinci. Just this year, I verified this morning with both of their teachers. Aiden hasn't done anything since October 14th. And what he has done is turned in blank assignments. Sophia hasn't done anything since February 10th. We do send the bus over there, but when the bus goes there, it is dark every time. They honk their horn, and I can't have the buses sit there and wait for them to get up and get on the bus to come to school. We are accepting kids to come back for in seat. However, we have had the administration, we have sat down and talked about this we are going to put them on hybrid and kind of put them on a probation period of seeing if they will come to school on Thursday and Friday. And we'll see how that goes, but we're not going to offer them 4 times when I have students that are wanting to come back to four days in seat to give them the space, because right now they're not coming to school to begin with.
And I have a report from Ms. Richardson. I'm willing to put this over for 2 weeks and see if they in fact do what Mr. Almack says is going to happen, and see if they do this. And let's see where we are in 2 weeks. Mr. Almack, either you engage an attorney or ask me to appoint one for you, but at some point, if you don't follow through, I am going to take the step that Mr. Brown is recommending. This has been a recurring problem. I understand that your children do what they want to do.
Yes.
And what they want to do is going to result in both of them not getting an education. I just can't permit that to go on. I am willing to give you a couple of weeks to see if you follow through, but also to make sure you have an attorney present before I order this very drastic remedy of actually removing your children from your care and placing them with someone who will make sure that they're in school. I want you to have counsel for that kind of a hearing. So
yes, sir.
If you are unable to retain Mr. Carroll's services, I suggest you contact my office and tell them you would like me to appoint an attorney for you so that I can make sure there's an attorney to represent you at the next hearing.
Okay.
Your Honor, I would ask
Yes,
that
sir.
an attorney be appointed now. I doubt Mr. Carroll will be retained, and this is just another stall tactic that we're going to get 2 weeks, and we're going to be in the same situation that we are right now. So I would request, school year is getting close to the end. And 2 weeks is critical. Will be another month before we're able to do anything.
I'm not going to appoint an attorney until Mr. Almack asks me to do so.
Well, he won $75,000 for my son, sir, in a lawsuit. So I'm pretty close with him after dealing with him for a year, and I've retained him before. And if you would like to speak to Aiden, he is up. He's right. Well, he ran back upstairs, so I told him to get out of the way, but he'd be glad to speak with you, Mr. Brown. So I would really like you to talk to the two children before you make judgments.
There's really nothing to talk about. I've seen the facts. They haven't went to school for years. There's nothing to talk about. Go to school.
And I've had mental health issues since I've been 24, but I mean, I'm trying to get them in school and be disciplinarian that I'm supposed to be, like the guidelines are set. But sometimes it's tougher to do than not.
I don't want to hear it. I don't want to hear it.
Mr. Almack, you've been cautioned.
All right.
The next step is indeed placing your children with someone who will ensure that they're in school. I'll give you 2 weeks.
They'll be there. They'll be there with bells on Thursday, Friday, Thursday, and Friday.
We'll see how you do. I'm going to keep a very tight leash. Shannon,
all right.
What time would that be?
So March 30th at 9:15.
That's a Tuesday, right, sir?
Yes.
All right.
March 30, 9:15. Like I said, if Mr. Carroll's not able or willing to represent you, just contact my office so we make sure we have somebody who's here ready to proceed in 2 weeks, depending on what I need to do.
Okay, sir. And I was cautioned, like warned in court, or hello?
Yeah, I'm sorry. I had two people talking at once. What, Shannon?
I just wanted to say we've had attorneys appointed for them in the past, so I would just use those.
Okay, yeah, that'd be fine. If he's unwilling or unable to represent you, call my office so we know, so that I've got somebody here at the next hearing in 2 weeks, okay?
Yes, sir.
And make sure you express to your children what I said here in court today, which is if they don't go to school, the next step I have is to actually remove them from your care and place them in foster care. Make sure they know that.
Well, I wanted my son to hear it, but all right.
Judge.
All right, we'll see where we. Yes.
I have one more thing with us, just so you know, next week is spring break. So we have a half a day on Thursday and we're closed on Friday. Now, if it's giving it 2 weeks for the kids to be here, which is great, but after the 2 weeks and the kids continue not to come to school, but with them being on hybrid for the 2 days a week, the kids need to be doing their schoolwork online, or it doesn't do anything just if they show up at school, because they will still need to continue to do their schoolwork online.
Thank you for adding that. So yes, not only do they have to be present, but they have to turn in their assignments for their online school.
All right.
And what
they need to be shown how to do them. They don't understand the computer, and I definitely don't.
Can they be given some instruction when they show up to school how to operate? I mean, does the school provide them with devices?
Yes, but like Sophie.
Hold on. I'm asking Ms. Cole.
Yeah, so every student has a computer, and we have provided them with computers as well. The kids know how to get on the computer because the teachers have done many Zooms with them. When Sophie was present towards the beginning of the year, she knows how to log on. She's been in the classroom and has no problem logging on. So she can get onto her schoolwork with no problem. And I'm sure Aiden can as well.
I'm talking about doing her schoolwork, writing with that little pad at the bottom instead of typing the number in. She has trouble with that. And I think Aiden just gave up, but.
Yeah,
If they could just get a refresher, that would help.
well, of course, we're gonna do a refresher because they haven't been at school.
Let's
well.
do that. I don't want to hear excuses. I want to see that all of their assignments are turned in. I want to see that they're in school for the days that they've committed to be there and that they'll be allowed to be there. And my plan is, if they are compliant, that I'll do another review in 2 more weeks. I'm keeping you on a very, very short leash. I'm keeping your children on a short leash. I'm not going to let any more of their educational opportunities slip away from them. And if there's any misstep, the next step is putting them in a home that will ensure that they go to school and do their schoolwork. Make sure they know that.
All right.
Thank you, Your Honor.
All right. We'll
Again,
see you back
Judge,
here in 2 weeks. Yes.
remember that we do have that spring break, so they'll be at school this week and next week. So if we come back and review on March 30th, the kids will technically only have this week in for school and 1 day or next week as well for just a little bit. And then they'll be on
All right.
spring break.
That's fine, as long as they participate every day as they're supposed to. We'll see where we are in 2 weeks.
All right, sir.
All right.
Thank you.
all.
Goodbye.
Okay, next up, Highland and Garrett miners. And this again is the file where Dad's in quarantine.
Yes, Your Honor.
I really don't know what else to do other than to adjourn it for 1 more week, and hopefully by then, my suspicion what's happening is the guys that are in quarantine continue to contract coronavirus and infect others. That's why this quarantine just continues.
The email I got said his unit is in quarantine. So I'm guessing there's probably a significant outbreak that they're trying to keep under control.
No objection, Your Honor.
I'm just going to keep adjourning it from week to week because we need to get rolling on this one. But as I said before, it's not fair that Dad doesn't have a chance to participate in the hearing. So we'll put this over 1 more week.
Let's do March 23rd at 9:30.
March 23 at 9:30.
Thank you. Thank you. We will request them again right now.
All right, and I forgot to let Ms. Cooling in to let her know that. Ms. Cooling, my apologies for not bringing you in. We're going to put this over. Is mom's an Odyssey host, correct?
Yes, that's correct.
Yeah, let me get her in too. I'm sorry, I should have realized what was going on. Okay, Mom is present from Flint Odyssey House, Shannon. Yep. And we got another notice that the father's unit is still in quarantine. We're going to try again next week. So that's March 23rd at 9:30. And we'll just keep doing this till he comes out of quarantine, but I don't want to put it off any longer than that.
Thank you.
Anything else? Anything else the court needs to address on this file today?
All right, thank you.
Okay, thank you. Counsel, can you all remain? I'm going to go off the record and stop the live stream.